And you pay only after the goods have been delivered. Because that's also the contract, not so.
Yes, but then the financial instrument for the project is an irrevocable letter of credit. So that credit letter has already been sent.
Hold on, no problem. But in my view, that letter of credit area, the contract requires that you pay by letters of credit, not so.
Yes, in addition, we should establish it upon the sign of the contract. So already you have paid.
Upon the signing of the contract for every 50 ambulance.
Yes. Upon the signing of the contract for every 50 ambulance, since there was no advance mobilization, advance payment, that LC was a security that you have to establish ahead.
No problem. The signing of the contract for every 50 ambulance. Is it the contract for the contract for every 50 ambulance?
Pardon?
Is it the contract for? I'm saying upon the signing of the contract for every 50 ambulance.
Yes.
Is it the contract for every 50 ambulance?
The contract is for 200 ambulances in tranches of 50.
Good, hold on. So that contract for 50 ambulance is different from this one?
No. The contract is one contract for 200 ambulances, which has been broken down within the contract for every few. You establish LC for every 50 tranche. So you have 4 LCs for the 200 ambulances.
No, that part I disagree with you. But if you look at the terms of the contract, it's quite clear. And it should not be difficult for you to accept because really it doesn't put you in any problem at all. That does not put you into any difficulty. I don't know the Minister of Health, the Minister of Finance. So for me, if you accept that, then it doesn't put you in any difficulty.
See, the problem I have in accepting that for you, is that in there are letters that confirm that both from government and from our principal, that is for every 50 ambulances. That confirms that. And I'll be tendering those letters in. So I cannot go against what the letters say and the contracts say because I was the agent at that time. Japan Business was the agent.
Hold on. LCs on site. Payment shall be in euros. First, if we said there shall be no advance payment.
Yes.
What does advance payment mean?
What it means is that you are not the supplier was not going to be paid any cash, any money for him to use in procuring all the accessories and everything to manufacture. So the manufacturer will use his own money to buy the ambulance vans, all the accessories from across the globe, with the security from government being the LC. And the LC has conditions precedent.
Hold on. Okay. Yes, advance payment not mean paying in advance of the delivery of the goods.
They said no advance payment.
Yes, advance payment means that you are paying before the goods are delivered to you.
No, they said no advance payment. Not that there's advance payment. Yes. No advance. Mean that you will not pay.
Yes, until the goods are delivered to you. Also.
Yes.
So until the goods are delivered, you don't pay at all.
You don't pay.
Also. So, and then also it goes ahead to say that payment shall be in a free manner. LCs on site of goods. In fact, what is the even LC on site of goods? What does it mean?
What LC on site of goods means is that when you ship the documents, when you ship the goods, when you ship the goods from your port of origin, the bill of lading of the goods is what you use as
LC on site of goods means means when the goods have been shipped.
They have been shipped.
Not and then the goods have been delivered in Ghana.
No, when the goods have been shipped. Because you have gone to do principles. So what I'm trying to explain is that so you use the bill of lading. You use a bill of lading. You use a bill of lading.
You establish the LCs after pre-shipment inspection. No dispute about that.
No, the LC is established as soon as you sign the contract. You establish the LC, and that becomes the security comfort for the supplier to invest his money.
It says LCs on site of goods shall be signed upon the signing of the contract.
Yes.
For every 50 ambulances.
Yes.
Yes. Which contract is this? It's not a contract for every 50 ambulances. So in under this main contract. This was like the main contract.
The main contract and LC for every 50 of the 200. You said so. So the contract is not saying that government should establish one LC, which is 15.8 million euros for the whole 200 at a go. No, government has a bulk contract of 15.8 million euros. Now, this contract will become, the ambulance will be coming in tranches of 50 ambulances. So you establish your LC for the 50. When that 50 have been delivered and everything sorted out and handed over, another LC is established for another subsequent 50 until you finish all the 200. That is what the contract says. So the LC that was established.
Even then, hold on. I don't agree with your explanation. But even then, this explanation, that's not what happened in this case.
Okay, what happened?
Yeah, that's not what happened. Yes, because the LC was established even before pre-shipment inspection.
Yes.
Also,
yes.
There was no pre-shipment inspection. So, so it means there was no basis for the LC to be established in the first place.
No.
That's really not your problem anyway.
Right, that place, in that particular place, you are getting it wrong. If you may have patience for me to explain.
No.
You are getting it wrong there because when you establish LC, the LC had conditions precedent for it to be on it, and the condition precedent states that you can only cash the LC when you present shipping documents, which is bill of lading, to the Ghana International Bank of the buyer. Before the LC can be honored. So even though the LC was established upon the signing of the contract, was supposed to be established upon the signing of the contract, it cannot be cashed or honored. It becomes a form of security for the supplier to invest his own money. And when he ships the ambulances, he can then send a bill of lading to your bankers to then honor the LC, because that is a condition precedent.
In any case, in this case, even the LC was actually cash. Everything, that payment was actually made before the goods were shipped.
No.
The goods got to Ghana.
No.
Oh, yeah.
He couldn't have the supplier. There is no way under the sun he could have cashed the LC before the shipping document, which were condition precedent, was presented to Ghana International Bank. Even when he presented the documents to Ghana International Bank refused to honor the LC, raising issues of discrepancy, which came back to Bank of Ghana, which later went to the Ministry of Health, and then Animana authorized Bank of Ghana through Ministry of Finance to pay because they had sorted out the discrepancies with Big C. That time, around this time, or the ambulances had already arrived in Ghana. You are not privy to this one, I'm telling you.
In my view, if we agree to this theory, it's so simple. The theory of the case.
Not agree to the way you want to go. The way you want to go about it.
So let's agree. Let's describe it that way. Let's describe it that way. Do you want to go about it?
Okay,
if
fine.
Agree this way. For me, it makes it simple.
Yes, it will make it.
It doesn't also involve. It doesn't involve any difficulty for you.
Yes, I agree. I understand your point. That it doesn't.
When you say there's no advancement, yes. When you say there's no advancement, ordinarily meaning in Ghana that you don't pay until you get your goods. Now the contract here, even the clear terms, unless maybe you guys did not draft the contract, it says LCs on site of goods shall be established upon the signing of the contract for every future.
No, the contract was drafted by government. It was done by government. And it was an LG department perused the contract and approved the contract for government.
It is not a problem whether they approve it. Every contract is actually approved before later when they are implementing it. Then problems.
You see, what the difficulty I have with your position is that, you see, frankly speaking, fine, as you are saying, if I agree to your position, how you want to go about it and how you want me to go about my answering questions and things, if I go by that way, frankly speaking, I'll be dishonest. Because I know that is not how it's supposed to be. And I'll be dishonest, in such a way that I'll be assisting for someone I know is completely innocent about this. For example, Atu Forsen, to be jailed because I knew something was wrong, was not the way, and I decided to keep quiet and to answer the question in a way that will make your case better for you to jail him. I'll be battling with my conscience. That is the problem I'm having. Anytime you bring up this issue with Yonikulende, when I went to Yonikulende's place, anytime you bring this issue, that is my problem I'm having. Because me, for example, I am in this case because I'm innocent and I'm going through ordeal. So I'm looking at another person also going to go through ordeal and through me because I know the truth and I decide not to say it because I want to help the AG make his case. And I ask myself, what is my interest in it?
I'm not asking you to really help me. I'm just going by it. Anyway, so that's fine. So this one was even just by the way.
I hope you get my difficulty.
It's on the phone. I don't even know that.
Oh no. Don't worry about that one. My issue. I'm just. Oh no. You and I will be meeting. You'll be meeting me at my cousin's place. And you've been bringing this issue up several times, and I keep telling you that I can't do that because it doesn't sit well with me.
Look at the terms of contract. The terms of contract are simple. It is on site service established upon the sign of the contract for every ambulance.
Yeah.
Do you understand? Yeah.
It's for every. So when you see the hand for every 50 ambulance, means that it's not only the 50.
Okay. Yeah. Okay.
For every. It means that it is not only 50.
All right.
Mean that there are a lot of 50s that will be following. So that is what I was trying to explain to you. So frankly speaking, the LC that was established was as a security for the supplier to invest his own money since there's no advance.
Yes, it is the same that was used to pay. Because LC was the means of payment and the agreement.
Yes. When the conditions precedents are met.
Which is what? That agrees that they have some documents.
That he has the bill of ladings, the ambulance have been shipped and the bill of ladings are presented. That is when you can catch the LC. So until you ship the ambulances, you can't catch the ambulance, you can't catch the LC.
It was that in this case also.
Yes, in this case, yes. When he shipped the ambulances, he then presented their documents to Ghana International Bank. And then Ghana International Bank refused to honor the LC and raised issues of discrepancies, which was later cleared by Animana at the Ministry of Health for payment to proceed. And that is how he was paid. So, frankly speaking, if there's somebody who authorized this payment to go on, even though in Ghana International Bank raised issues of discrepancies, it's Animana. He was authorizing those payments.
But you include when you had the Bank of Ghana officials and the Minister of officials and even Setepe say that no payment can go on except with Minister of Finance authorization. There's no way Minister of Health will authorize. In fact, Minister of Health actually even their letter they said no, they should go ahead and produce ambulances.
After that letter that Sheraite wrote that they should suspend production, those things was contrary to the terms of the contract, and that letter went to your office, the AG's office, and the AG debunked that letter and wrote his legal opinion and told her that they should proceed. So AG, that letter had been destroyed by your department, by your ministry. So that letter is of no value. It is the AG's legal opinion that overrode that letter, and Ministry of Finance had to implement the AG's opinion.
Yeah, and by the AG's legal opinion, the terms of contract were honored.
Yes.
Or the terms of contract were breached.
And because they were already breached, and the AG wanted them to honor it. So that Sheraite's letter that you want to rely on is of no value.
They honor it. Honor the terms of contract.
The ministry. Yeah, they still didn't honor some part of the contract. They honored the LC part, but when it came to the pre-shipment inspection, they refused to honor that particular part.
Okay.
So they waived their right to go and inspect, and then they turn around and blame people for you not going to inspect to rectify any manufacturing defect that the pre-shipment inspection was meant to cure. So Sheraite, through her negligence and refusal to implement the pre-shipment inspection, created this problem. That's what I was trying to head.
The reason for that is that that's my timetable for the rest of the.
That means that you are not going to be around.
So, yeah, and then even next week, the whole of next week, I'll not be around. If there's a way of, if you not even finishing next week, I would appreciate.
Oh, no, okay, no, I'll not finish next week. I don't think I'll be able to finish because the documents are many. So you surely go and come and meet me.
Oh, no,
but that will also depend upon the judge's behavior.
You can bring one medical excuse next week.
Okay. Okay, fine. If you bring a medical excuse next week.
I said you. How can I bring a medical excuse?
No, you are saying that I should bring a medical excuse next week.
You can if you want.
But brother, you want this one to issue bench warrant for me again?
Right. Anyway.
Because you can see that I was really in admission, struggling for my life, and she issued bench warrant for me to be arrested, and my name was put everywhere.
That's right.
Now, if I go and do another one, as you are saying, my brother, this woman will issue another bench warrant for me and destroy the little of my reputation left. She will destroy it.
All right. No problem.
But you will surely go and come and meet me still talking. So don't worry.
No problem. All right.
Okay. Thank you, my brother. Thank you, my brother.
It was in the public interest to admit the audio and video recordings obtained in breach of such rights. I'm reading from the ruling of Justice Efia Sewa Asareboche, page 22. At page 22, she begins to discuss a popular case we call the Kubaji case. And that case enunciates Article 18.2 of the Constitution, which prohibits the invasion of the privacy of people, the communication of the privacy of people or their property. But there is an exception, that if the invasion of the privacy is to prevent crime, for example, then that evidence will be admitted. So she said, it was in the public interest to admit the audio and video recordings obtained in breach of those rights. Accordingly, all objections relating to a breach of the rights of privacy of the accused persons, including recordings without warrant, were held to have no merit and overruled. This being a criminal proceeding and in the interest of reciprocity, because should the situation be reversed and the law enforcement seeking to have such evidence admitted, the application would likely be granted. The pen drive containing the recorded conversation is admitted. That's this conversation you just heard is what she's referring to. The pen drive containing the recorded conversation is admitted. In any case, it has not been denied in principle that that conversation actually took place. Let's begin this morning's discussion with Kweku Ansah Asare. He's former director, Ghana School of Law, and director, legal education. He's in private practice and also manages and trains lawyers. Gary Nimakomafo is Director, Legal Affairs, New Patriotic Party. He's here in the studio. And we'll have Sameh Jamfi, National Communications Officer of the NDC, also join us via Zoom. Mr. Ansah Asare, thank you so very much for your time this morning. After all your advocacy on radio and TV, insisting that the Attorney General had badly misconducted himself with some criminal implications, and that he should either resign or the president should dismiss him. This is the verdict of the court. 5 different prayers or applications, call them, seeking to impugn his integrity and have him removed or have the case terminated, have failed in the court of law. Okay, we just had a little problem with Mr. Ansah Asare's line. Let's try and get him back on the line so we can hear him briefly. We understand he has an important event to attend to. Yes, Mr. Ansah Asare, if you can hear me, My question to you.
Loud and clear, my brother.
Great. Did you hear my question then?
Repeat it, please. Come again.
After all your advocacy and your listening to the tape and coming to the conclusion that the Attorney General had misconducted himself, even including criminal implications, and you refer to a precedent where an Attorney General suffered in a like fashion, you said he should either resign or he should be dismissed. The court has determined this matter. What do you say?
Thank you, and good morning. I don't think the court has determined the matter. There was an attempt to do a mini trial, that is a trial within the main trial. And that application says that the substantive case is still ongoing. But having said that, I think that we need to understand how the judicial process works. If a judge has jurisdiction, that is competent to try a case and come to a verdict, the judge can go right and can also go wrong. So if you have jurisdiction to do right, you also have the jurisdiction to do wrong. That is to give a positive or a negative verdict. Now, having listened to the tape this morning for a third time, I think that the Attorney General is not doing justice to the whole nation. Mind you, the Attorney General, under our Constitution, is the guardian and protector of the principle of justice. So he's the guardian and defender of the public interest. Now, here we are. If you listen to Richard Japa, he kept saying to the Attorney General, you and I, we've been discussing this matter at my cousin's house. You and I, we've been discussing this matter at my cousin's house. He doesn't tell us the number of times that the Attorney General, Godfrey Dame, and he, Richard Japa, met in Japa's cousin's house. By the number of times, that is one. Then in the course of the conversation, which was in a private conversation between the two of them, we hear Richard Japa say, ask the Attorney General, how you want me to do what you're bidding, how I go about answering questions, how I should go about answering questions. My brother, this amounts to coaching, and it's a serious offense under our law. It amounts to contempt of the court. It amounts to obstruction of justice, which is also a criminal offense under our law. Under the Constitution, any such offenses amounts to contempt of court, for which the Attorney General can be attached. I'm surprised that the defense has, up to now, not brought an application to attach the body or person or the Attorney General. Let him face the wrath of the law. What he has done is contempt of court, pure and simple, and he must be made to suffer for it. Then in the same conversation, Richard Japa reminds the Attorney General that I, Richard Japa, am innocent, and therefore I wouldn't do anything that will incriminate an innocent person merely because you want incarceration for that person or because you want your prosecution to succeed. I won't do that. He kept reminding the Attorney General. Now, arrogantly, the Attorney General comes to tell us soon after the court ruling that all the public comments, the commentators have misled the general public. It is he, the Attorney General, who has misled the court. And if we had we were operating in a different system, the judge would have cited the Attorney General for obstructing justice in the court, which itself also amounts to contempt of court. We have what we call in law contempt ex facie curiae, that is contempt committed before the court. So the Attorney General has tampered with a witness, and in criminal jurisprudence, we also have what is known as witness tampering. Witness tampering is any conduct of the prosecutor or defense to influence or intimidate a witness to go one way or the other. Is the Attorney General seriously suggesting that what he did not or does not amount to witness tampering?
Right.
In my considered opinion, his conduct amounts to witness tampering, and that is also contempt of court.
Mr. Asasari,
because it is an extension of obstruction of justice.
Mr. Asasari, we can deal with whether or not, as the judge, in dismissing all the applications, she makes sound law when she says, I can't find, the basis in law to give you what you are asking for in almost all of the things that they ask for. We can deal with that, but the question here has to do with what you have listened to and what she has also listened. The judge has listened to the tape 10 times, and she says, after having listened to the conversation between Richard A3 and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on exhibits CAF2. Those words were uttered by A3 at about 9 minutes to 10. In the same vein, the declaration that A3 was innocent and, quote, going through ordeal, end quote, but was being asked to help make the case of the AG better, was not made by the Attorney General, but was made by A3, Richard Jakpa, to which the Attorney General responded. Based on the exhibit CAF2, the Attorney General is heard speaking to the third accused person. He is prosecuting outside the court and discussing the evidence and even making suggestions as to what the accused should do to obtain an adjournment. That, to my mind, may negate the principles of right thought. That said, however, the third accused cannot by any stretch of imagination be seen to be the one to be procuring new evidence or cowed by the conversation, but the whole situation could be a source of discomfort and discomfiture. What she says, as the court finds here, is the fact on the tape, is it not? To hear somebody talk about you trying to get me to help you to do your case, we don't hear it from the Attorney General. We hear it from Richard Jakpa. Is that not so?
Well, it was in response to a question. We were not there. But if the other conversationist says that repeatedly, I wouldn't want to do what you are bidding me to do. No, I wouldn't. I'm an innocent person. Now, if you ask me to do it and I implement it, the result will be this way or that way. Remember that all of us have different listening ears. What I hear from the same audio recording may be lost upon you. There are certain vital instances or assets there that may be lost on you or me, that a third or fourth or fifth person may find contained in the same document or audio. So different listening here. That is one. Number two, making inferences judicially. It's not as simple as we are making it sound. The judge was legally enjoined procedurally to return findings. She has seen the witnesses, she's observed their demeanor, and she's saying that as far as she's concerned, it couldn't have been the Attorney General. The larger general public is saying that reality is different from perception. Reality is different from perception. The larger general public is saying, or majority of us are saying that we heard it loud and clear. So if the trial judge says that he needed to make a finding in order, to return a verdict, and he made it, if any person is aggrieved, the release lies in an appeal. Any of the party, be the prosecution or the defense, if they feel aggrieved, let them go on appeal.
Right.
That is why we have the appeal court. They can go further to the Supreme Court.
Right.
I am not thereby suggesting that the judge's conclusion was right, but I have witnessed the discussion suggesting that if a judge can go right, the judge can go wrong.
In the manner in which the public commentary seems to project in an almost conclusive, manner that the Attorney General did wrong, is it not an invitation rather to the judge to make inferences and to make, interpretations and make conclusions from the conversation? Otherwise, what she has written down as what transpired on the tape is accurate. So people say, the Attorney General is heard saying, if you do it this way, my way, it will not pose any difficulty for you. People want the judge to make inferences from that, make conclusions out of that, and so on. Earlier, the communication from the Attorney General's department through the spokesperson was that in the meetings that were spoken about, the Attorney General simply told the witness to speak the truth. So if I ask you question A, just tell me the truth. The expectation on the judge, is it fair that she should be making inferences rather than telling us exactly what has been heard on the tape?
Thank you. Remember, in one of the interviews I granted to your station last week, I reminded the general public that the public of, the court of public opinion is overwhelmed. If you go there, you get lots and lots and lots of views. It's like watching Black Star. All of us become coach. Therefore, the judge sounded a caveat that please stop politicizing this issue. I am not going to be influenced by what you say in public. I am only going to perform my constitutional duty in accordance with the dictates of the Constitution.
All right.
The judge already sounded that. Now, where I find the judge's conclusion wrong is this. The same judge said, Mr. Attorney General, you need to be strongly advised to recuse yourself. That alone ought to have formed the basis of deciding whether to admit or not to admit, or whether to rule on the fact that the Attorney General did not say that, or the Attorney General said that. She said that we should be strongly advised. What informed that advice? What informed? And
she had said,
the advice.
she has said, Ms. Ansasari, she had found
moral turpitude.
Yes, she had found and said, let me supply this briefly. She had found and said that where the Attorney General is heard asking the witness to go for a medical excuse, that for her, she said, is discomforting.
My brother, the words are mere words, but words are powerful. The court was not there to decide whether a conduct will result in discomfiture or not. The court had been called upon, the court had been invited to rule on the propriety of what the Attorney General had said. All of us have heard the tape several times. I am a lawyer, and I'm saying that I find everything wrong with the conduct of the Attorney General. It is not every lawyer who is going to toe my line, and it is not every judge who is going to rule that this is, this can only amount to a discomfiture, and therefore, discomfitures, do no harm to the law, or discomfitures do not make bad cases. As far as I'm concerned.
But her point is this. You are asking me ultimately to make an order that there has been a mistrial. And she says that in our body of laws, as far as the legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of the alleged misconduct of a lawyer, either for the prosecution or the defense. And then she says, well, if you have issues, you can go to General Legal Counsel or somewhere else, but not here. Then she says that the Attorney General is talking to the witness in the manner he's heard talking to him outside of the court at a time when he is prosecuting him in the court. It's discomforting. So on the side of the law, I can't grant what you are saying, what you are asking me to grant. But in all, propriety, it appears that something hasn't been done right.
Well, the offense of witness tampering or obstruction of justice can be committed before or during or even at a trial if it is intended to intimidate or influence the witness. It doesn't matter whether it was said in the courtroom or outside the courtroom, because outside the courtroom can be an extension of the courtroom. Here is an Attorney General leaving a courtroom, accepting an invitation to meet one of the accused persons in a private home. He shouldn't have done that. He did it. It is offense number one. Number two.
It doesn't matter. It doesn't matter. It doesn't matter that in that meeting, as they report, he was only saying, tell the truth.
But he lied.
Who lied?
He has lied. In telling Richard Jaffa how to go about excusing himself from the agenda itself constituted coaching. And we have remember that we have had an instance in this country where in the course of the trial of Nyantechi and Opon and Yeboah, who attempted to overthrow the NLC in 1967, in the course of the trial, one lawyer, one of the defense lawyers, S.K. Amufa, has alleged to have coached Yeboah, Opon, Nyantechi, the two of them also. And he was convicted. We have several cases where lawyers have had to appear before the General Legal Counsel, where they have suffered the sanctions laid down by law. Now, the General Legal Counsel is mandated under Section 17 of the Legal Profession Act, 1960, Act 32, to discipline erring lawyers. The Attorney General is first and foremost a lawyer, and therefore is subject to the disciplinary measures or procedures of the General Legal Council. Now,
Okay.
the General Legal Council is constituted by persons of 4 Supreme Court judges, including the Chief Justice, and the next most powerful person is the Attorney General. So the reference or referral to the General Legal Council, is called comfort. The General Legal Council, will be a toothless bulldog in this matter because the Attorney General is a stalwart in the composition of the council. I will not advise or suggest to the Defense Council to go there.
All right.
Unless the Attorney General is suspended or made to step aside. Nor the Judicial Council, because, again, the Chief Justice is the chairperson of the Judicial Council, and the next most powerful person is the Attorney General. So this creates a legal quagmire. We find ourselves in a conundrum. And the Attorney General, both the Attorney General and the court will now, find themselves in some legal tricks, like Amatedu's proverbial dilemma of a ghost. Shall I go to Cape Coast or Elmina? Should the defense go to the General Legal Council or lodge a complaint about the ruling to the Judicial Council or the Chief Justice? In neither of these instances will any good verdict.
All right. Okay, so
we will not.
You
So
clearly.
I maintain my stance that
Right.
the Attorney General must resign honorably or be fired. Now, the judges advise that he should, to him, the Attorney General, that he should strongly advise himself. It is the President who has, to call the last shots, and he will not do it. And the whole nation is, sitting on tenterhooks. Now, we have very able seniors in this country, senior lawyers in this country, who have not spoken publicly. They are rather bemoaning in their individual homes.
All right.
To their spouses and members of family.
My final question to you. My final question to you, and if I may get a very.
Let me make this point.
Okay.
We are all beneficiaries of the spoil system. Country broke or country no broke, we dey inside. Therefore, people will not talk. This is what is giving strength to our erring ministers of state on whether to resign or not to resign. Because at the end of the day, our culture in Ghana is Ehura Ebejo. Ehura Ebejo. And therefore, let them say it. They can say it 1 million times, I will not resign.
Okay.
Right. No more.
So here's my final. Here's my final question to you, and I'd like you to be very brief with that for us. Thank you for your time. You clearly disagree with lawyers like Kwame Jan and Kweku Pencil, who say that the Attorney General is not subject to the General Legal Council. In fact, Kweku Pencil goes further to say that the Attorney General and his officers are not subject to the General Legal Council, which will be wrong in any case because just recently, Chief State Attorney Nekwe Tete lost his license to practice as a lawyer. He's been disbarred, completely removed as a lawyer because of his involvement with Weyome, in which situation about 400,000 cedis went through his wife's bank account or so. But my question to you is this. We understand that on the day the judge was going to deliver her ruling on these applications, an application has been filed in the Supreme Court seeking to prohibit her from dealing with the applications and for certiorari on the basis that she had decided that she was not going to hear legal arguments and that denial is substantial and infringes the law, and because of that, this case should be heard by the Supreme Court and potentially all the rulings we have now that we are, discussing, will be thrown away. What do you think about that situation? That she should have allowed legal argument, and not allowing legal argument, what wrong has happened?
Friend Parmesan and Peku Pencil are probably wrong in suggesting that the Attorney General and the state attorney, that the Crown or state lawyers are not subject. They are lawyers. The legal profession has, several branches. They belong to one branch. All of us are subject to the disciplinary control of the General Legal Counsel. So that is one. Number two, if the judge has jurisdiction to go right, the judge has jurisdiction to go wrong. This is not a matter, inviting certiorari. The Supreme Court, in certain cases or instances, may be called upon to determine certain issues. Under the Constitution, a judge, if there is an issue, with respect to interpretation of a provision, and the judge feels that the judge doesn't have the jurisdiction to do that, the judge must, or the court must refer, that issue to the Supreme Court. I am not aware that, the Supreme Court has spelled out guidelines, other than what were set out in 1987, which have been followed ever since. If you want to apply for certiorari or ask for a review, there are clear guidelines. Once your application falls within the shadow of the guideline, then that is it.
My question is there anything wrong for a judge to say, you have filed your application, the date to move the application is this date. You don't have to move it. I'll give you my ruling. Is there anything wrong with that?
There's nothing wrong. The judge is the master and controller of the court. And the judge can invite arguments orally, that is viva or we were okay, or documentary. What she did was right.
Okay.
In my opinion.
Thank you very much. Thank you very much, Mr. Ansansari. All right. So, Kweku Ansansari, you just heard there. I think we entered the law school just when he left. He was the director, Ghana Law School, and director, legal education in Ghana. And he's presently also training lawyers and in legal practice. Gary and Sami, welcome to the show.
Yes, Samson.
Right.
Yes, can I go on?
Yes, please go on.
Good. I think, Samson, good morning to you and good morning to your Charles viewers. Good morning to Senior Sassari. But you see, listening to the submissions he makes on the ruling, clearly, I'm clear in my mind that he hasn't read the ruling. It's very clear.
Which part?
All the ruling. The entire ruling delivered by the court on the 6th of June 2024. It is clear. If you try to copiously quote portions of the ruling for him to look to change his position, he stuck to the same position and didn't change the position. Clearly, he hasn't read the ruling. It's very clear. Something, what has brought us here? Now, let me take my time and in sober reflection, deal with this particular matter. We are here because somewhere in 2014, 2016, a charge was said to have been filed against Mr. Atufosin and two others. Now, one is been discharged, so he's no longer. That they've caused financial loss to the state.
That's 2021, December. 2020 and the trial 2021, right?
No, 2024, 2026. That is when the facts.
No.
When was the charge filed?
The case was filed
2021
in December of 2020, okay. And then in January of 2021, it began.
It began?
Yes.
Good. Very good. Now, Samson, this case that was filed in 2021, at the time it was filed, I'm very clear in my mind that the Republic had their own evidence and their own investigations, built the theory of their case, put their facts together, and then filed before the court. There was no issue about what? Recorded a tape at that time.
That's correct.
Good. The prosecution mounted a box, called their witnesses, closed their case. A1.
Okay, so it is this way. Filed December 2021, and in January 2022, the process began. Yes.
Right. But then it is clear that the issues complained of started between 2014 and 2016. These are the facts, isn't it?
That's right.
Good. Now, something. At the time when the prosecution entered the dock, mounted the dock, led evidence in the case and everything, closed their case, the issue of so-called doctored tape had not arisen. For even backtrack, at the time when settlement conference was going on, document was being exchanged by the parties. The so-called tape had not arisen. The case closed. Submission of no case was filed by A1 and A3.
Richard Japa and
Atuforsen. And this is very, very, very instrumental. The court said, no, it's a case for you to answer. Now, let me go to that point. You see, it is very, very, very instructive. Very, very instructive.
I've read the entire ruling on the submission of no case.
No, yes. It's very instructive in terms of the findings made by the court that a case has been made for them to open their defense.
Right.
So let me refer you to page.
They are only supposed to punch a small doubt
Exactly.
in the Republic's case, and the Republic will lose.
Exactly. Now let me go here. The judge said, and I'm referring to page 4 of the ruling that we are dealing with. He said, submission of no case dated 30th March 2023. This court concluded that a prima facie case has already been made to merit all the 3 accusations then to open their defense. Now listen, something. That the matter was settled. That the ambulances in the state in which they were delivered could not serve any useful purpose. But the assertion was made by the cross-examination and the evidence put forward, particularly A3, that there were moves to fix the defects, thereby proving the case that there was no loss occasion to the state. It means that at this stage, there is a case which has been made that the loss has occasion. But as to whether the loss is willful, and who caused the willful act, that is yet to be determined.
And I'm happy you read this portion.
Good.
You know why? Because I had heard commentaries, including respectfully from Sami Jamfi, right after this decision, throwing out the applications. That suggested that the judge had done something in predetermining the matter.
No.
By suggesting that the state had established that the vehicles that were delivered were without useful purpose. But if you read the decision, she actually highlights this. She says the matter was settled that the ambulances, then she begins to highlight, in the state that they were delivered, that's highlight, in the state that they were delivered, could not serve any useful purpose. She did not say, emphatic, that the matter has been settled, that the ambulances could not serve any useful purpose in the state that they were delivered.
Good.
Yes, go on.
Now you see something. At this stage, then A1 mounts the box. Leaves evidence in chief, is cross-examined, call witnesses, 3 of them, and closes his case.
Atuforsen.
Now, Atuforsen is here. He said, further, there was the issue of what authority the first accused person exercised what he asked for the LC to be issued. It is a case of the prosecution that the LCs were issued without due cause and authorization. The prosecution is stating that A1 had no authority, had no authority. He stated, among others, that the agreement that culminated in the delivery of the defective ambulances, which cannot be used in the condition that it is. Now, A1 also called the Minister for Finance, who came to testify for him, and closed his case. All these stages, there's nothing called recorded tape. You see something, and this is very instructive. Prosecutors go to court, do their investigation, build a theory of their case, take the evidence with them, put it before the judge. Just accept that there's a case for you to answer. You also come and mount your defense. A1 closes and it's off the dock. A3 now comes because A2 has been discharged. Then at this stage, you start your evidence in chief. You put your witness statement in there. And then you are now being cross-examined by counsel for A1. A1 and A3 are on the same path. And even the direction by the judge that A1, lawyer for A1 cross-examine A3, is a settlement of appeal, which they find a stay.
Because they believe the Attorney General should do their work before they come in.
But they are on the same path. A1 and A3 are on the same path. Their interests are coterminous. All right?
So actually, for those of you who have not followed, one of the applications seeking to hold the hand of the judge not to do anything is in respect of this particular one that is pending in the court. Because they are saying that you have done something that we disagree with you. You said, you said Ato Forson's lawyers should cross-examine Richard Japa before the Attorney General. We don't agree with that. That's not what the practice is. So that's why one of the applications was asking for a setting stay, and the judge refused it. Yes, go on.
And even in the appeal that they filed, they didn't particularize any particular error of law made by the judge.
We'll not go there. Let's stay here.
No, you see, I'm just trying to get the public, something, you and I, and my good brother, come on, sit where you are not feeling well.
Let's stay here. Let's not attack the process on appeal.
Fine. We owe a duty, a solemn duty, to educate the public and to avoid this propaganda and the mischief and the public deception and all. You have to let the public know what are the facts of the matter, because until the press conference of the NDC that they did, I was not following this case. They brought us into this case. By now going to court to even follow the case. I have not been to court on this case before. Then we are now being told that under cross-examination by my very, very good friend Tamaklo on Japa, he now suggests that, well, there's a certain tape that you are trying to contrive evidence to lie and all the blah, 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 blah.
Because
this ruling,
whilst Japa is giving his testimony,
yes,
the Attorney General makes a certain intervention about suggesting that Japa is, doing the bidding of Ato Forson.
Yes.
Or is seeking to help Ato Forson.
Yes.
So Japa gets angry and then says, you have done this to me, I will spill the beans.
Yes.
And this is where we are.
So this is a beans. This is a beans, Samson. Having listened to this tape with sober ears, you will see clearly that all the statements that were being said by Japa did not emanate from the Attorney General saying, say this, say that, say this. It is very clear.
Why was he not protesting them?
Who was protesting?
The Attorney General. When you and I are having a conversation,
yes,
and I'm saying, we have met here, you have been doing this. I'm saying I can't do this. Why was he not protesting?
You see, you will see from the tape clearly there was a disagreement about LC.
That's correct.
The agent's understanding of what the LC and its import meant was different from what the Japa was saying. And then we were disagreeing. All of a sudden, because Japa knew that he was recording. He knew he was recording what he was.
He started sense, but
He started now suggesting things, saying things, and even dropping names. He started dropping names.
My question is, why did the AG not object to that kind of thing?
Let me tell you something.
You have said this, you have done this, you have been seeking to get me to do this.
My conference with the AG, subsequent to the leakage of this particular tape, he tells me, look, Gary, there is not a full tape. Because the discussion even started with the issue of me going for international arbitration and me seeking to get an adjournment because I was prepared for international arbitration. And the gentleman also having earlier on not been able to attend court, but then the bench was issued against him. And then being afraid that now if he doesn't go to court, then he may get another bench warrant. So I said, if that is so, then you have to seek for medical report. And all that portion of the discussion have been taken away.
He said,
now, what report?
He said,
hold on.
Go ahead.
Hold on. What communication? Something I've known you for over 20 years. We talk. We talk on the phone.
Yeah.
We meet, we speak. What communication will you call me? You will not even greet me. No salutation, nothing. And all you see is that in the middle of the stream, I'm talking, or you are talking. Which communication doesn't start like that? I think that we have to approach this particular matter, and we are now, it's as if, because of an existence of a certain tape, one-sided tape which has come up, the issue before the court should be thrown away. That, because now somebody is saying that the tape exists, there is no issue about financial loss to the state, whether willful or not willful, whether the state has lost money or not lost money, everything should be thrown away. And then we should now rely on existence of a certain tape recorded by one person to throw away the entire case, say there's a mistrial.
You know, if our jurisprudence accommodates mistrial, it doesn't mean that there will not be a trial of the case itself. Mistrial will mean that there will be a pause, and then you have to go and reassemble your facts and come back. But because of a certain development, including misconduct, it has led to, the case having to be stopped.
You will need to assess the entire case and see whether there has been a miscarriage of justice, whether there has been some contrivance or some evidence. You have to make a full assessment of the entire thing to say that, look, some injustice has occasioned the person, and therefore it's a mistrial.
Okay.
In this particular case, Samson, let's be honest with ourselves. From the very beginning of the proceedings all the way to the time Satifosi closed his case, who has introduced an issue that he hasn't been given fair hearing in the matter? Even when Jakpa himself started mounting the box, he had the tape with him. He did. The tape was there. This tape that he relies on now at this stage to try to cause confusion into all of us and to take our minds off, this tape was there. This tape, according to them, was recorded some few days or so when he had mounted the box.
The day he was going to mount the box.
So if he found the tape relevant, the tape was relevant to disproving this case or show some confusion in the Attorney General's case or whatever it is, why did he not at that time file for leave to amend the witness statement that, look, I think that this particular information is relevant to me, showing that my innocence. This particular tape, Samson, it's a red herring. The tape has nothing to do with whether the financial loss was caused or was not caused. And I'm surprised that this tape is now taking all of us our focus from the real issues in contention, which is whether or not somebody's act or omission has occasioned the Republic or willfully.
We all don't share the same view. You heard Ansari.
Oh, yes, that is why. I heard him. That is why I'm saying.
Resign or be sacked. Misconduct.
See, that is why I'm saying that. Something, listen. You see, we are confusing the matters. The issue about whether the Attorney General will resign or will be sacked, one lies with appointing authority.
Their political decisions.
It's a political decision. Or he himself sitting down to say, well, maybe I want to resign. Okay? The issue of whether there is even a breach of our ethics rules is not the courtroom. It's not the courtroom. That is why the judge says, I'm not to deal with this particular matter here in the courtroom. Right. There is no rule of law or practice.
Okay.
That is dealt with in the courtroom.
Right. There's an issue that is being raised about the judge not allowing the lawyers to move their motion and to argue. Samson,
I was in court. I told you that I had not been following this case, but
I was there. I was just next door. I was in the other court. I was also busy.
Courtesy, the NDC press conference. It made me now go to court to be listening to this particular matter, just to leave everything I'm doing, to just go and sit down and listen.
Right.
I was in court. Sammy was in court. He was sitting about 2 blocks from me. The motion was moved. You see, Atukuba delivered a certain decision at the Supreme Court. And
experts say 16
alloys.
Republic versus Court of Appeal, right?
Yes, 16 alloys.
What did they say?
Once a motion has been filed and all the parties have filed and responded to the application, and the date for hearing is due, the return date is due, a judge is not obliged to admit viva voce arguments in court. The judge can rely on submission filed before the judge and determine the propriety of the application. Now, this particular one, My lord, the judge said, Mr. Tadoshori had raised a legal objection. And then we hear the legal objection because it was on a point of law. And he spoke. I was sitting there. Someone was sitting there. He spoke. Attorney General responded to the legal objection. So when they say they did the legal objection, they didn't allow them to speak. I don't understand. What I remember they saying is that they are first on process at the Supreme Court.
Yeah, but the legal objection is separate from moving the motion.
That's what I'm saying. But no, why the motion has not been moved?
Your point is that there's law that says that's immaterial.
The judge said, I'm not going to admit oral viva-voce arguments in court.
Good.
But the law is settled that once the due date, the return date is due, and even if you are not in court, the lawyers are not in court, the judge is not obliged to invite you to come and the judge can look at the paperwork and determine the ruling.
Do you realize that sometimes we misapply that authority?
Why?
Because the ratio is not actually that. Why do we give a date for hearing? When you file an application, why don't we say, because you have filed it, come for ruling? Why do we give a date for hearing?
Oh, something. We all know that by practice and procedure, you file an application, the return is fixed for you, depending on number, because you must give the other side notice of the application.
Good.
I mean 3, 4, 5 clear days, depending on what you are going to do.
Right.
And the nature application that you have filed before the court, the other side responds to the application. It's on record. You go there. The judge sometimes can look. I've been in court severally. Some judges will say, Nimakon, you will not speak here today because you are going to give a lengthy submission. So you will not talk.
You will
not talk.
Familiar with it.
Yes.
But I'm
so
saying
you will not talk. And then they say they are going to rule based on the papers. And I sit down.
You and I have used expertise Eastern Alloy to make this point on Newsfile once, that yes, a judge has the right to go ahead and do this.
Good.
But maybe you want to go and read it again, and you find that the ratio is different. That in that case, the one who brought the application was actually not there. And then the one who had to argue the other side went ahead and did their business. And then later he goes to, the appeal, complaining that I was not heard.
And the Supreme Court said that the court has no obligation. It's not obligation. That's in the letter. Right. Obligation.
Is there a practice direction to the effect that when you have complicated applications, the court should adjourn for at least 2 weeks for written submissions?
Something.
It's a practice direction we know that it's followed, right?
Something.
This case, do you think they should have been heard?
Something. You see, let's take it this way. You and I are not the ones to give the judgment or the ruling on a matter.
The ruling is now.
No.
So the judge is official. That's why we can discuss the ruling.
Wait a minute. You see, what you have filed your process in court, and the judge says, I need the 1 hour to write my ruling, my reasoning ruling. The judge's duty is to write a reasoning ruling, decision. Right. Not that some of them will write anything, but just write a reasoning decision on why he's going A or why he's going B. And the judge says, I need 2 days to do it. And he indeed comes back with a very copious decision, solid one.
Okay.
What else again is there to discuss? And in this decision,
there's a 33-page decision.
It is very clear.
33-page decision for the application by Richard Japa, and there's a 14-page decision also for Kesela Tofor. Let me go to
this decision. Lastly, has really exposed the propaganda, the lies that the AG had sought to contrive evidence or had made Japa to say certain things. Indeed, on the tape, it is very clear. If you listen to the tape with open eyes, with not the jaundiced ears, you realize that it's Japa who was saying what he was saying, knowing because he was recording the communication.
Okay, Sami, so here...
Sami, you agree with me?
First, the substance of the decision. All 5 prayers gone. Mistrial is not known to our jurisprudence. And if you hit the check, you find that you won't find mistrial. And she leads you to where that may be possible in jury trials. And he says, this is not a jury trial. So it's not something that is familiar in summary trials. This is a summary trial, okay? Right. Then where you ask for inquiry, she says, a judge cannot, whilst hearing a case, order an inquiry. And that one too is unheard of. What you are bringing is outside what is going on in the courtroom. So that too will not happen. Then the other 3, discretionary, injunction. You want an injunction. Injunction is discretionary relief. She says from the weight of the evidence, you don't deserve it. And then the
stay of proceedings.
Stay of proceedings. That one too says, injunction says, I cannot injunct the Attorney General from doing his statutory constitutional duty. I can't do that. And she gives you the authorities, which we know. And stay of proceedings too, she says, well, that one too, I don't think there's an exceptional situation. It's difficult to disagree on the point of law for dismissing the applications, correct?
Not at all. There is ample basis to disagree with the reasoning of this decision, because I think the judge got it wrong on many folds. But even before I go into the decisions I think she got wrong, it is important for us to situate this discussion in a certain context. This is a conversation about justice and justice delivery. It's a conversation about the ethical and professional conduct or misconduct of a person in whom the prosecutorial powers of all of us is vested. And we must all know that the issue of justice affects all of us. And so in discussing this important issue of justice, the very foundation of our existence and democracy, let's be fair, let's be objective. I don't say that Fred Dame is my friend or my party member, so even when I know that this is wrong, I will try to defend it. Now, as I'm saying, there is something good that the judge has done that I have been commending her for, and I want to reiterate that commendation. It has to do with the judge delivering a detailed, well-reasoned ruling in a matter that she could have just given an off-the-bench ruling.
Really?
I mean...
You can't give a bench ruling on this.
Well, she says she could. She had the discretion.
Oh,
so she said that.
so.
Yes, on the day of the ruling.
She had a
that she had the discretion to give an off-the-bench.
5 applications of such serious
She said she had a discretion.
Okay.
And so for me, to give these detailed 34-page, 14-page rulings, commendable, okay? At least it helps the development of the law. Another thing that I commend her for is the admission of Exhibit CAF 2, the audio recording, which was played by the NDC at our press conference sometime last 2 weeks, which our friends in the NPP, led by the likes of Frank Davis, Nana B, Paul Adomotre, and so on, said was doctored. In fact, the words of Frank David were that the tape on this very platform in this chair had been spliced together, and I'm quoting, spliced together, which goes to the authenticity of the tape. Now, the public and viewers of Newsfile need to know that when this tape was brought to court, the Attorney General could not raise any objection to its authenticity. The Attorney General did not mount any challenge.
But he was not given the opportunity to make an argument.
No, hold on. The Attorney General had an opportunity to file an affidavit in opposition. He could not, no, you will not interject. You will not.
Go ahead.
He could not
the tape
file...
was attached to a
supplementary affidavit. Yes.
To
yes. So the Attorney General could file a supplementary affidavit in opposition. In the first place, he could not swear an affidavit in the first place. He had to employ the services of a proxy.
Which is
material.
Which is allowed.
No, I will tell you why it is not proper. But the Ghanaians need to know that Godfrey Dame could not swear an oath to deny the authenticity of the tape.
It is allowed in law for him to get someone else to swear an oath on the matters that have been brought against him.
The law only allows that person to swear that oath on his behalf if that person declares his source of the information.
The source will be the Attorney General.
Yes, and I'm saying that, no, that source, if that source is the Attorney General, then that is hearsay. But in any case, for the ordinary man watching, why would the Attorney General, who has always been in court, and against whose person these allegations are being made, decide to defer the denial of those serious allegations to a proxy? when he himself can go under oath?
Because he knows the repercussions. The counter is that you were setting a trap for him.
Oh, why?
That once he swears to the affidavit,
yes,
he's the one going to make the argument. He's going to refer to his own
but even non-lawyers sometimes are allowed to testify.
And then secondly, once he swears to the affidavit,
yes,
you may also apply to the court to cross-examine him on it.
Yes, but why is he afraid of?
He has a right. He has a right not to want to speak to it.
Let me tell you what he was scared of, in our opinion. He was scared of lying under oath because he knows that if he swears that affidavit and it is found out that anything in that affidavit is false, he will go to jail for
That's a presumption.
Now, and yours too is a presumption. So, something, the point here is that all the things the MPP have been saying about the tape being doctored, spliced together, they could not say it in court. The only challenge the Attorney General raised on his feet was a challenge on grounds of breach of the right to privacy.
Article 18.
And like we rightly said here, the judge upheld our argument that that right is subject to exceptions.
And last week we said that even if it is stolen,
it doesn't matter.
Once it is intended to
once
crime,
you are committing crime in your privacy, or you are violating the fundamental human rights of another person in your privacy, that right to privacy does not hold. And the judge dismissed those allegations and admitted it. So the lies, your friends in the MPP, the tape is doctored, all that has fallen flat, number one. Now let's go to the things the judge got wrong. Number one, the issue of Odi Oterem pattern. I have a total different view. The issue of whether or not an application has been moved is different from the issue of whether or not the court has a discretion to allow legal arguments. Lawyer Tadiosore and lawyer Aziz Bamba are not complaining because they were denied the opportunity to make legal arguments, even though they would have preferred so. And in my opinion, the judge should have allowed for oral arguments in his discretion, because the judge herself concedes that this is a novel legal issue. And the norm is on such novel legal issues, the judge, in exercising his discretion, would want counsel to address the court on certain important matters so that justice can be done. That was a discretionary matter,
right,
governed by Article 296. And I think that the manner in which the judge exercised the discretion in disallowing legal arguments was an abuse of her discretionary power under 296. But the most important point here is about whether they were heard or not. On whether they were heard or not, it is clear that they were not heard because, like you rightly pointed out, when an application is filed, it has a filing date and a hearing date. And it is written boldly on the face of the application that court to be moved on so and so dates. You go to court, the norm, as I have seen within the short time that I have been a lawyer, the norm is that the court, once counsel for the applicant is always in court, the court will always ask the counsel for the applicant to move the motion and say, my lord, I have before you a motion for so and so, pursuant to so and so. I move in terms of the motion paper, the supporting affidavit, and exhibit. That at least is always allowed by the courts.
Not always.
Why?
In practice,
yes,
if you are using the court every day as a practitioner, you will know that in practice, you can file an application. I have an ex parte motion. I go there. The judge doesn't need me to move it. They will say, yes, counsel, I've seen your affidavit in support of it. It is granted. Go.
No, you see, you can talk about what some judges do. I am talking about what the law requires. That once parties have brought a matter before you, the least you can do for them is to give them a hearing, not legal arguments. The legal arguments point, I've dealt with it. It's
but if it is just about the facts,
governed by 296.
If it's just about the facts, then the facts are already on the affidavit.
This was not just about the facts. This is the case where a preliminary objection had even been raised.
All right.
So once you deal with a preliminary objection, you then now move to the application proper, and counsel should be allowed to say something about the application that has been filed. That was not done. But the most serious thing was that an application had been filed in the Supreme Court seeking to restrain the judge from delivering the ruling that day. And the judge sits in open court and says, even if I am held in contempt, I will come to you as a lawyer to defend me. Is this something that we want to encourage even ordinary men in society to do? That today we have a president of our country saying that because the matter is pending in the Supreme Court, I will not exercise my constitutional powers, right? To assent or refuse assent of a bill. because the matter is pending in court. And the judge says, yes, you have filed it, but I will still go ahead. And if the Supreme Court holds me in contempt, I'll come to... Please, I thought that
basically
left much to be desired.
So
that
basically they were seeking to arrest the ruling so that she doesn't deliver.
Exactly.
Okay.
Number two, the judge was terribly wrong when she said that there is no statute that confers on her jurisdiction to give orders for inquiries, mistrial, and so on. Because Article 140 of the 1992 Constitution is clear.
Criminal law.
Yes.
Criminal law.
The High Court.
Criminal law.
Yes.
Criminal law derives from the law itself.
Yes.
The judge's jurisdiction must be statute-based.
Yes, I'm coming. So let me read to you.
Should we debate this?
Yes, and I'm trying to tell you that there is statutes.
No, you are reading article...
Hold on.
You are reading the Constitution on general jurisdiction for the court to exercise.
Hold on.
Yeah.
The High Court, 141, shall, subject to the provisions of this Constitution, have jurisdiction in all matters, and in particular in civil and criminal matters, and such original, appellate, and other jurisdiction as may be conferred on it by this Constitution and any other law. So the Constitution grants the High Court jurisdiction in all matters, civil and criminal, subject to the provisions of the Constitution.
Fortified by statute. It said there, right there, fortified by statute.
No, where is
the
statute?
Statute that,
where? There is no statute here.
That delimits the
There is no statute or any known law that says that a court, number one, cannot exercise general jurisdiction in criminal matters or inherent jurisdiction in criminal matters. So you allow me to make my argument. I'm saying that 141 doesn't talk about any statutory jurisdiction. It says that the High Court shall have, subject to the provisions of this Constitution, have jurisdiction in all matters and in particular in civil and criminal matters. Now, there are decided cases on this, right? Decided cases. If you look at the case of Republic versus High Court, Kufuridua, S. Party Nyame, and another, right? The court was clear. This is what the court said. Nothing was presumed to be out of the jurisdiction of the superior courts unless expressly so stated. But nothing was presumed to be within the jurisdiction of the lower courts unless specifically stated. I can go on and on and on. Now, this is the point. Once the Supreme Law of the land has given you general jurisdiction in all in all matters criminal and civil, our contention is that unless, based on this decision, a law expressly takes away or outs that jurisdiction, you cannot say you don't have jurisdiction.
She points to the provisions of the criminal and other offenses.
Which doesn't apply to the case, Section 8. Which doesn't apply.
Which pertain to jury trials. And she says,
no,
mistrial in any case happens in jury trial.
This is not true.
This is not a jury trial.
Let me even show you why it is not true.
Say you disagree.
I disagree. The reason why I disagree is that even apart from the general jurisdiction she has, and on the basis of the decided case the authority have cited, shows that until that a law expressly takes away or outs that jurisdiction, she has to exercise it to do justice. There is such a thing as the common law, which is part of the laws of Ghana. Article 11(1)(e).
And common law must not be mounted for criminal...
No, there is no law. What the law she cited says is that you cannot prosecute and convict a person under the common law. We are not asking for Godfrey Dami to be prosecuted. We are asking you to make orders subject to the common law. That is what Dr. Bassett asked. And this is the point. It is very clear, and I can cite another case to you, okay, that every court, especially superior courts, let me put it that way, has inherent jurisdiction to provide for matters not even provided for in statutes. And if you look at the common law, courts trying criminal matters have inherent jurisdiction to prevent the abuse of their processes, the processes of the court, and to ensure fairness in the legal proceedings. Something you understand. And in so doing, under the common law, courts trying criminal matters are able to make orders for inquiries, orders for mistrial, and so on. And that common law per Article 11(1)(e) is part of the laws of Ghana.
Okay.
Aside that, there is Article 12(1), which enjoins all organs of states to uphold the fundamental human rights of all citizens or all persons in Ghana. 19 talks about the right to a fair trial. Article 142 gives the High Court jurisdiction to enforce fundamental human rights. And then you cannot say that if in the course of hearing a criminal matter, the right of an accused person to a fair trial is being violated, the court will not exercise inherent jurisdiction to prevent that abuse of that right. Again, the court got it terribly wrong in assessing the evidence that was placed before the court. Who can listen to this audio you have played this morning and say, in good conscience, Samson, that Dame did not ask Jakpa to implicate Atufose? You hear in the tape at several points Dame telling Jakpa to testify his way, and that was not going to create any difficulty for Jakpa. What was going to be the effects of those testimonies or answers he was soliciting through that unprofessional way from Jakpa? If Jakpa went to court to testify the way the AG wants, i.e. saying that payment was made via letters of credit even before goods were shipped, was that not going to implicate Atufose for willfully causing financial loss to the state? The judge makes no reference to those portions of the tape. Then the judge goes to the part of the tape where Jakpa is heard saying that if I do this, I will be dishonest. The judge says those were the words of Jakpa.
But that's true.
Yes.
That's true that those were the words of Jakpa.
Yes, but in assessing evidence, you assess it, number one, as a whole. Number two, a judge is allowed to make inferences in assessing evidence. And so if in a conversation, I tell you, Samson, that you told me to go and implicate somebody, and that if I do that, I will be dishonest and I will be sending an innocent person to jail, and you have not done it, what is a reasonable person, any right-thinking person would do? Deny. Dame never denied. The only thing Dame said, that this is a telephone conversation, I don't know whether I'm being recorded. That statement in itself shows that Dame had an ill mood.
He hasn't said...
And the judge is saying...
Wait,
no.
Dame hasn't said this, but let me play the devil's advocate again.
No,
hold on, let me tell you this. Let me tell you this.
Yes, where the court has done it right, we have the right to commend it. In our opinion,
where we disagree,
we express our divergent opinion.
Hear me. And last week we went through this, and many people came at me that I'm heckling you. I'm getting the best out of you.
No problem.
Now watch this.
That's that you must give me the time to.
And for you who think this way, I have no any such intentions.
Yeah.
Now, Dame has not said this.
Yes.
But imagine when they say the tape has been pieced together.
Yeah.
It is possible that where you are expecting the judge to make an inference, that inference could lead into trouble when there is the full audio provided somewhat, and it shows that he had protested that comment, and yet that was cut off.
Senior, respectfully, that is a red herring because the judge herself, Dame herself, did not raise any issue about the incomplete nature of the tape. And the judge never made any reference to any incomplete tape. You understand? So that was not even one of the things she considered. In this case, ask yourself, why did Jakpa say on the tape that I cannot help you, and that if I testify the way you want, I answer the questions the way you want, I will be helping you to convict an innocent person? It is because prior to that, the Attorney General had told him that, look, this is very simple. If you do this, if you agree to this, it won't create any problem. Then he replies by saying, I can't do that because if I do that, I will be helping you.
So
then
bottom line,
and says,
we need to move on.
No, then he continues and says, I have been having several meetings with you in my cousin's house. Dame doesn't say, no, I've not been having meetings with you. And the judge says, because only one party on the conversation said this, then it is not true. And he, my senior at the back, Gary, and the judge, they say that, oh, this is a tape that only made 2 weeks ago. Really? The tape contains evidence of interactions with Mr. Jakpa that happened as far back as 2022, the outset of the case in court. And if you look at Jakpa's affidavit before the court, he speaks about interactions with the Attorney General as far back as 2022, for which reason he says... Hold on.
Gary's question is, why didn't he bring that in the process?
For which reason Mr. Jakpa says the whole case has been brought in mala fide and not bona fide. Why didn't he raise it at the beginning? It's neither here nor there. Jakpa is now doing his case. Ato Forsen has not been in meetings with Godfred Dame. Jakpa is now doing his case, and this is the right time. Now, let's make something clear for those who are learning.
I need to move on.
Because sometimes you ask a certain question which may give a wrong impression. Godfred Dame has not been acquitted of any charge of misconduct.
Godfred Dame has not been charged with any charge of misconduct.
Yes, and he has not been acquitted. What the judge said at page 8 was simply to play Pontius Pilate. That my forum is not the right forum to pursue issues of professional misconduct against the Attorney General.
That you agree.
And that there may be another forum.
That you agree, don't you?
I disagree because the court is also a forum. The two are not mutually exclusive.
A quorum for punishment for misconduct.
Every superior court has an inherent jurisdiction to ensure that, number one, its processes are not being abused.
Even in the Supreme Court.
Yes.
When Nekwe Tete's matter came up, the court had to make a referral to the General Legal Counsel.
I'm talking about a prosecutor.
They didn't punish.
Look, you are saying that if a prosecutor, in the cases, the Canadian cases and the external cases the judge cited, what was the substance of the case? What was the issue? It was about prosecutors prosecuting people for crime, engaging in misconduct, and those courts being called upon to say that, look, your processes are being abused, accused persons are not likely to get a fair trial, therefore invoke your inherent jurisdiction to prevent that and to protect the rights of the accused person. You can't say that a judge in a superior court trying a criminal matter doesn't have that inherent jurisdiction. And so something finally, what I will say on this matter
in a minute
is that for Godfred Dame to be strongly advised by a judge as Attorney General to stay away from a criminal matter he is prosecuting, and the judge gave her grounds. She says, I strongly advise you to do so to protect justice, and so that the public will have confidence that matters before the court are only determined in the court and not elsewhere. This is the most damning verdict ever given by a court against any Attorney General from the days of Geoffrey Bink. And it shows what a disgrace Godfred Yeboah Dame is. And this is the more reason why he must go. And if he doesn't go,
the application to prohibit the judge is still
triggered.
Has been filed and pending in the Supreme Court,
the application to do what?
To prohibit her, yes.
Yeah, that one is still there. So, I think that
there's a possibility. There's a possibility
and
that the Supreme Court will hold that what she did was wrong. There's a possibility. So
but whether that in itself will invalidate the ruling, that's another matter. Gary, but I am very sure that there will be
just a minute
an appeal.
Because we have to move on.
I know that there will be an appeal.
Because I won't get him to speak again.
Give us more time.
No.
Because
we'll go to the next
we can do it 30
No.
5G.
You see,
this one is about justice.
My brother,
5G, we have more time.
My brother has really misled the public.
And a minute.
Correct that one. You see, on the issue of the source of the tape. That was in the position. Tados conversed it, and the court overruled it. So you don't say that the court didn't deal with it, that matter. It was overruled in the court, European court.
What?
I mean, the issue about the source of the tape.
No. The source of information of the principal state attorney who testified, who saw that affidavit for Godfred Dame. So you are missing the issue.
Thank you.
Look.
Yeah.
My time is up.
You asked the question about something I said about the judge saying that it is settled that the ambulances could not be used. Let me clarify that point in 1 minute.
No, something.
What we disagree? Oh, senior.
No.
I'm sorry. I'm your
okay, so when you are done, you will not interfere with him.
No, I will not. I will just do this.
I'm holding 2 minutes, then you will do 2 minutes.
The reason why we are saying that statement the judge made was very wrong and unfair is that as we speak, at the time she was giving the ruling on this matter, these 5 applications, it has not been settled per the record of the proceedings that the ambulances in the states they were brought into the country could not be used. What is the evidence of Mr. Jakpa is that the ambulances in the state they were brought in were not supposed to be used. And that there was an agreement to that purpose, that the medical accessories must be shipped later, installed, before they were used. And that if they were even used, in the state they were brought in, it was going to void the warranty.
You're making the same statement differently.
No. Could not. If you say, when you are trying people accused of a crime, that already it has been established that the ambulances were not fit or could not be used, that is serious. You are trying to say that already...
Could not be used until what you have said ought to have been fitted.
No, she didn't say until. She
added it. I'm rendering it that way.
You see, there has not been any settlement of any facts that the ambulances as they were brought in could not. What the agreement is that, what is the case, the testimony of Jakpa is that the ambulances were not supposed to be used in that state. The ambulances have not even been handed over to the government.
Something.
The medical accessories are still at the port for 7 years.
Okay.
Something.
Okay.
So how does the issue of loss even arise? Why are the court to determine?
Gary, wait, before you come in.
Okay.
It has to be made clear here that, in fact, the judge did not make a prejudicial
You read
statement.
it. You will see
did
the
not
prejudicial
prejudge
statement.
the whole thing.
You read it.
They
could not be used is the issue.
Okay.
Because that is not the testimony of Jakpa. Jakpa's testimony is that they are not meant to be used.
I didn't.
If you say could not be used, what you're invariably saying is
I highlighted it but didn't mark the page. But which page is it?
Page 4.
Page 4. Thank you. So on page 4, yes, he says, the matter was settled that the ambulances, then she begins to highlight.
Yes.
In the state that they were delivered,
highlight ended.
Could not serve any useful purpose. Wait. She doesn't end there.
Yes.
But the assertion was made per the cross-examination and other evidence put forward, particularly by Jakpa, that there were moves to fix the defects, thereby proffering the case that there was no loss occasion to the state.
Yes.
So this is fair to the
Jakpa is not only saying that there were moves to fix. Jakpa is saying that the ambulances were not intended to be used in the first place.
Thank you. Point
until the right accessories were installed.
Yes, thank you.
That is also the evidence.
Thank you.
Let me put it on record. That the judge has now ordered that my good friend Tamakolo should now file the tape, which they brought in the pen drive. Japan now brought the thing in the pen drive. Now we should go and file it. They are now going to file it and serve all the other parties and now seek to tender. So let me the point be made clear. What was attached to Mr. Shori's application, application, that's a different matter altogether.
Yes, it was admitted.
They are now going to, but it's not surprising and curious.
Okay, thank you.
Hold on. That curious. That a recording which was done by Jakpa, the third accused person, found its way onto an affidavit, some better affidavit filed by Mr.
It's strategy.
It's strategy. So they are on the same side. Now you agree with me? They are on the same side.
Well,
they are on the same side.
Atuforcing didn't go into the box to.
They are on the same side. They are on the same side.
He got somebody else to do.
You may be in opposition.
So all these are strategies, and once the law allows it,
you see, but
he did not mount He did not mount the witness box in his own defense. Atuforcing didn't do that. The point I was making to you earlier was that AG is also entitled to use somebody else. So that's the law. Thank you. We end it here.
You'll be interested
No.
You like the law.
No.
It's not always educating people on the law. Let me read this one.
We take a break here. We take a break here. Thank you very much. We'll be right back with the next.